Okay, we'll make a start. Welcome everybody to this presentation on the Senior Managers and Certification Regime. I'm David Allison, one of the Directors of Compliance Management Services Ltd. You probably know my colleague Norman Hughes, who's the other half of the anti-tech of compliance. Unfortunately, he's on holiday at the moment, so I've drawn the massively long straw to be here with you today. My colleague Susan Reeves, to my right, as a guest, will be actually doing the presentation. And if you've got any questions, which you may well have, we'll try and deal with them. We'll deal with them at the end. If there's anything we can't answer, and bear in mind that the SMCR is still under consultation, like a lot of things with the FCA at the moment. They like consultations. And there's another one to come out yet as well on this subject. We'll try and answer them as best we can. If there's anything we can't answer today, we're quite happy to take that offline afterwards and come back to you individually. So, without further ado, I shall pass you over to Susan.
Okay. Well, I hope you all get something out today and enjoy it. But if not, I'm sure you've got my P45 ready, ready for that. So, yeah, we're going to be talking about the SMCR. So everybody's probably seen by now the consultation paper that's come out. So we thought talk about a little bit of background first of all as to why this is happening. So basically, after all the banking crisis, you all remember those pictures of the queues outside Northern Rock and all that happened in the banking sector. Parliament obviously wanted the FCA at the time to sort this out and bring sort of more accountability in. So what happened was a series of different things, the Banking Reform Act of 2013, and then the SMCR regime has applied to banks since 2016. So all started as a result of the crisis back then. Okay, so the business plan last year, the FCA are very serious about this. There's obviously quite a lot of things on the agenda that they're trying to do all at the same time, but very much that they're talking about culture and governance, individual and conduct, all those words simply repeated all the time, behaviours, etc. So that's a big focus for them. Okay, so what was the purpose of the SMCR? Well, it's basically approved persons regime, and it is more onerous than the approved persons regime. So again, addressing those things like standards, trying to get a better reputation for the financial services industry from the UK, more and more things to do with governance again. But the big thing, I think, is accountability, personal accountability, as well as corporate accountability, looking at really improving culture in organisations. But they are looking at consultation documents, trying to take a proportionate approach to it. So they're not trying to bring in all the rules that go to the banks to everybody, and they're very much trying to make that clear that they are looking at different sectors and different sizes of firms, and that they would also take a different approach when it comes to sort of monitoring and governing this. Okay, so looking at the timing, so the consultation is open until the beginning of November. So I believe the MGAA is collating response back. And there's a separate consultation paper for insurers, so that's all happening at the same time. The consultation papers that are coming later in the year are to do with more the practical elements about how they're going to transfer the approved regime to this, and some standard templates and so forth. But that'll be later in the year, and they've said that it's likely to be in 2018, but we think it very much will be towards the latter part of 2018 by the time this all comes into play. So the regime, really three different things around the individual accountability and culture. We've got the senior managers regime, certification regime, and the different conduct rules. So what we're going to do is talk through those in some detail. First of all, though, the FCA, going back to that proportionality that they're looking at different categories of firms. So we've got the core firm, which will be the majority of the MGA membership. So they have the baseline requirements, and then you have the limited scope firms, which tend to be the sole traders or people that the primary industry isn't insurance and intermediation. So you've got limited scope for, and then you've got the enhanced firms, which are much more complex firms, and there will only be about 360 firms in the UK fitting into that category. So the one that's really, the criteria which is really applicable to the MGAA space is if you have an annual regulated income of over £35 million. So if you're in that bracket, you're kind of in the wrong presentation because we're going to be talking about call firms.
First of all, is there anyone here who has got a regulated business levy of 35 million or more?
We're quite close, so that's why I was going to actually ask the question at the end, because it talks about, I think in the paper it mentions about overseas as well. So I'm sort of trying to see what the distinguishing, so if it's actually regulated income, because I don't know if they're regulated in their own countries or if it's, I had taken the stance if it was a loose binder at least, even if it's in Australia, then it's still regulated in the UK.
Yeah,
the FCA rules. So we need to look into that.
Yeah, there are bits in the
be
paper that talk about overseas firms and UK branches. So, but that's outside today's presentation.
No. So I think we're quite close, but we still want to hear about the call.
Anyone like to have 35 million?
Yes, the way it says 35 million, but the explanation that I'm from an insurer rather than an MGA, but our core business is all delegated authority underwriting, so we have MGAs doing most of the underwriting for us.
The other thing that I think might be worth mentioning is if you are over that threshold, then your figures drop. You can't just drop out. You've got to run to 12 months, haven't you? So the FCA are very aware that there may be that sort of line that goes in and out. And they'll be looking at a particular way of how you're managing that particular risk. So be very, very careful where you sit. We're also discussing on Monday, when we're at the open door meeting in Lloyd's, about the situation where a company may decide to break itself apart because it's very much in that arena and they don't want to get in there. So if they're sort of something like 35, they may break down to 20 and 15 if they can do that. And they're looking at that as well. So be very careful on what you do. As David said, the jury's still out on this.
It's also possible in the consultation paper to opt into the enhanced regime if you want to. I can't see why anyone would want to. But they throw that possibility out there.
And this currently excludes the ARs, doesn't it?
The ARs are subject to another consultation. Yeah.
So let's talk first of all about the senior management regime here. Senior management function. So they are, as it says, a new type of control function, and they really only apply to very, very top people in the firm. So the people that really make the decisions. Just like approved persons, they will require approval before they take up the position. So there will have to be applications submitted and so forth. We've looked at the senior management functions, but really we think there's only really these three that will apply to the MGA space. We've got the senior management function 1, chief exec, the chair, and the executive director. But it's important to note that you could have more than one function, and if you do, you need to apply for both. If you've got two, you need to be putting 2 applications in.
The chair is the only non-executive director that requires approval under the new regime. Under the approval. Oh, was that the next slide?
Yeah, thanks. My glamorous assistant.
Oh, yeah.
Yes, shut up. So non-executive directors, they are not classed as senior managers, which I think in some of the feedback I'm getting from the groups we attend, that's one of the things people are actually querying with the FCA as to why that's the case. But they're not currently, according to the consultation, classed as senior managers. But they could, of course, be chair of the board, in which case they would need to be under the scope of that. And they won't be any more on sort of the FCA register anymore because they no longer will have any need to be on there because they're not senior managers.
What's the equivalent roles for partnerships? So no partnerships all end up being approved persons sometimes. So if you follow your partner, therefore you're considered the executive director.
It's the same as
there's a senior manager function of a partner.
Okay.
Yeah, like the old CF board.
The senior managers need to have a statement of responsibility designed for them. And again, in the next consultation paper, they're talking about sort of templates for these things, but they're not looking to make it overcomplicated. What they want it to be is very, very simple, so that the firm knows, the individual knows, and also the FCA will know exactly what the senior manager is responsible for. So when it comes back to accountability, they can have a look and say, well, this was on your watch. It's got to be given to the senior manager, but it's also got to be given to the FCA as part of the application. So they need to be prepared. Kept updated as well, so if they change roles or have different responsibilities or different prescribed functions, which I'll come on to in a minute, they have to be kept updated, because the FCA wants to be able to look at that document as a living document, which will actually really at all times say what that person is responsible for. So it's not a case of just something on the shelf you just send in, forget about, doesn't get looked at for years. So that's the key thing to note, because it will have to be resubmitted and there is a change. There's a new statutory duty of responsibility as well, which means that they will be responsible as senior manager for what is basically under your watch. So if your role, if something in the firm goes wrong, or there's a breach of FCA rules in the area that you're responsible for, you have this duty of responsibility for it. The burden of the proof is with the FCA, so what they will be looking to do is that you've taken reasonable steps. I mean, obviously in companies you can't control everything that everybody underneath you does, but you will be expected to have taken reasonable management processes and reasonable checks and measures and things, and otherwise questions will be asked of you to do that. Enforcement action, fines and so forth, which could be for the individual or the firm or both, and obviously all of the fines that the FCA gave are actually public information, so they're all on the, you can actually find out all the fines that were charged last year and see who those were. So it's really sort of important that this personal accountability gets across to the senior managers as well as the firm. Yeah,
that publication of the misdemeanours on the FCA website is actually quite interesting. And if anyone, has anyone ever looked at it? It's on there. You can see who's been fined, what they did wrong, how much they were fined, and going back for the last several years. So the Swinton's things on there, and little breaches of like client money rules, and people getting fined 10 grand, 20 grand, some cases 600 grand. It's really fascinating information. Dig behind it as well, all public. So, and that will be on here as well if anyone falls foul of this.
But they are, when they say about they talk about proportionality in the enforcement as well, so it will be very much depending on exactly what's gone wrong, what measures were taken. I think they did some attempt at managing the situation, so it'll be interesting to see what comes out of that. We mentioned the prescribed responsibilities, so these are new responsibilities which will go on top of somebody's basically their role. There's 6 extra responsibilities which need to be divided out between the senior managers, and it's really to make sure that this is taken seriously. So these prescribed responsibilities are all relating to the SMCR, all conduct and prudential, again, so they're making sure that they're allocated at the beginning of the regime so it's taken seriously from day one. And the prescribed responsibilities they would like to be given to the senior manager, who's not only the most senior person, but the most experienced, the person that's at the top of each one of these issues. And they're saying they should normally be held only by one person. So generally you can share a prescribed responsibility, but that would only be in exceptional circumstances, and you'd have to be justifying why that was the case. So these all need to be given out between the senior managers. If
you've only got 2 senior managers, which some MGAs may well only have, or one, then they'll have to take all those responsibilities and divvy them up between them, so they'll end up with more than one each.
And this all has to be put on the statement of responsibilities that they've got as well. So, what are they? PR1, you're responsible for implementing and overseeing the senior management regime. PR2 is obligations under the certification regime. So, PR3 is obligations regarding notifications and training of the conduct rules. we'll come on to that in a minute because it's more than just kind of giving staff a training course, but we'll talk about that in a minute. Financial crime, responsibility for CAS, that applies even if you don't handle client money because it's still risk transfer and all sorts, so there is still an implication for MGAA. And P6 for ensuring that the firm's highest governing body is aware of all the legal and regulatory obligations that it faces. We talk about certification regime, but we don't think this will come into the
Yeah, the certification regime really, a lot of companies won't actually make any difference because most of the certification functions that the FCA are consulted on really don't apply to general insurance intermediaries. From our reading of the consultation paper at the moment anyway. But it's useful to have an awareness of this.
Yeah, we included it. The certification regime applies to staff who don't fit into that earlier box of the senior managers, but who's really do have an impact on the firm and its customers, and its role could have serious harm to the reputation of the company, the industry, and so forth. These people, they used to be the CF29 function, the senior management function. So if you have people those, that they would come under this one, but they will no longer be approved by the FCA. So anybody in this box won't have to apply for approval, and they also won't be on the FCA register any longer. So it's only the senior managers that will be on that. Firms have to certify themselves, so they need to be looking at evidence of who is going to be passing the test for this. But the FCA expect you to be looking at things like honesty, integrity, reputation, training, personal characteristics and qualifications, all those things. That the firm will be issuing a certificate annually to these people, but the FCA will be looking at how did you make that decision, on what basis, what have you got to show. You be able to do that. So it's not just sort of be a top exercise that we just look at the beginning and don't keep alive. So the senior management function, like we were saying, is one of the certification functions, the CF29. CAS oversight function, you may remember in the previous slide I said that came under senior manager. If you've got a senior manager doing CAS oversight, they don't need to be reapproved internally as a certification function. They're already approved by the FCA as a senior manager. Anyone who supervises or manages anyone performing any of the certified functions, but they could apply to senior managers performing a different certification function. So a senior manager that's been approved by the FCA in a senior management role, taking on a certification role, but it's completely different, would still come under the certification function. But it is a little bit unclear at the moment until we some clarification following the consultation. The key thing is they won't appear on the register. Okay, so the conduct rules replacing the current statement of principle that we're all used to. But now they're going to be extended to all staff who come under scope of the FCA. So except that you don't have to include on this people like reception staff, security staff, cleaners, things like that. They don't need to come in. HR administrators don't need to come into it, but an HR manager would. So there are a list of in the consultation.
Quite a long list actually,
yeah.
People that wouldn't qualify.
Yeah, they're specified, aren't they? So if you don't come into that list, then they will be. It's really just really basic good conduct stuff. Nothing sort of revolutionary here, we don't think. So you probably recognise those, which would be statements of principle for approved persons. So all the integrity, skill and diligence, cooperation with the regulators, treating customers fairly, not conduct, all of that. But now it's not just the approved people that are subject to that, it's actually all the staff. So anybody working in financial services. You've got on top of that, you've got the senior management conduct rules. So I'm not going to read all of those out, but they're just really around the governance and controls. So they will be subject to those different conduct rules.
As well
as the initial ones. So things like if you're going to delegate responsibilities, I think that's a key one, that you are responsible for that and making sure you still take responsibility and oversee that. One of the key things on this is that you are expected to be training staff. I mentioned it earlier in one of the earlier slides. What they're saying in the consultation is that it's not just a case of you just putting them all in a room, giving them training on these principles. It's actually trying to show that you've made people aware of how it will affect them in their own roles and what sort of dangers and what sort of issues there could be in those roles. So there will be some planning needed in terms of actually identifying which of these things need to be highlighted to the members of staff.
And it's not rocket science. It's, if you employ someone, you want them to work to the best of their ability, they want to work honestly, they're working in the financial services industry, there's an expectation of that anyway. This is formalising it a bit more, and there's been accountability on firms, particularly if they have to take disciplinary action against someone for breaching one of these conduct rules, then that is now reportable under the new regime, depending on who's done it, whether it needs to be reported more or less immediately or as part of an annual return. So more accountability again between firms and the FCA.
More record keeping and so forth needed as well. Other aspects of the regime, so the fit and proper assessments, the firms will be obliged to do this for anybody that fits into these roles. So your senior managers, your certification functions, and now your NEDs, that's where they come in, the non-exec directors. You will be expected to be collating evidence on this, so not just completing a fit and proper check form anymore. Criminal record checks as well, for particularly the senior managers. So you'll need to sort of get the DBS checks in place or use an umbrella organisation that can provide access to those. And if somebody's had a significant time abroad as well, you're supposed to be contacting your regulators overseas to make checks there. So that's mentioned in the consultation as well. Okay, so it's up to the firm whether they want to do the criminal record checks for certification functions. That's up to the firm to decide.
And in that respect, there's no real difference between what you should be doing with approved persons anyway, to be honest. But I think the FCA recognise that a lot of firms don't. This is, again is saying, no guys, you've got to do this, and this is the new regime, and we're expecting this.
Yes. On the regulatory references, there is going to be a prescribed format, which they are, again, in the next consultation paper, going to be publishing that prescribed format. But you're expected to request them and produce them in relation to the senior managers, control functions, and non-exec directors, going back for 6 years. And the key thing is, if something new comes to light, so you've given a reference over and then you discover something, that somebody's done something underhand or whatever, you are obliged to notify the new employer as well. So there's going to be some implications there on things like if you've had settlement agreements or non-disclosure agreements, and they put in the consultation paper that they are sort of advising people steering away from NDAs if it's going to conflict with this obligation to be able to notify. So there are some sort of fine issues to consider then in terms of employment. But of course, you know, this will take legal priority over employment law. But it is a key thing to really consider as to what you're signing in terms of confidentiality and so forth going forward, because you will be obliged to notify if you discover anything after all those forms have been signed. So that's the point. So in terms of planning for it, what needs to be done? Well, it's really a board level project, because it is, as I think you can see, a few different things overlapping. There's a lot of HR, a lot of compliance implications. Training is a big one, and actually making sure it's bespoke to the individual. And the staff actually all understand this, and they actually understand that if they breach the conduct rules and they have disciplinary, then the FCA will get told about it. So I think that's going to need to be really highlighted to members of the staff as well. Otherwise, they just think it's just a set of code and principles that they've read, like any other code of conduct they've looked at. It needs to be really brought alive to them that they are accountable as well. And there's going to be quite a lot of processes and documentation needing to be updated as well.
The nice thing is it's not coming in tomorrow. We are thinking late 2018, probably the earliest, so we've got more than a year, so there's no panic at the moment.
But what you've got to think about is producing those statements of responsibilities for the senior managers, job descriptions probably need to be changed as well. Statement of culture and code of conduct that you have perhaps need to be updated with these new conduct rules. Looking at the processes that you have for fit and proper checks and things. Breach reporting, how are you going to do that? And all the record keeping as well. So quite a lot there. In summary then, as I said, it's all about those things we mentioned in the beginning. Accountability culture. But there will be some work to do to put all this in place as well. Just got to put this process as well, but this is when in the beginning, in 2015, when it came in into the banks, we just thought this was quite a good point to sum it up. The industry is characterised by weak accountability or by individuals seeking to protect themselves on a murdered on the Orient Express defence. It wasn't me, it could have been anyone, are less financially stable and more prone to misconduct. So this is why the FCA are saying, no, it is, you cannot hide, it is going to be personal accountability. But hopefully that is a whistle-stop tour of it, and hopefully you it's summed up how it's going to affect you. So but if you have any questions, please ask them now, or with our contact details as well. So, any questions?
Let me kick off. So to change that, you sort of very quickly passed over job descriptions. It's something that the FCA, when I've had meetings with them, with Dave Cooper et al., they've mentioned about some of the job descriptions may need to be revisited.
Yes.
And that opens up a can of worms in the HR side, isn't it?
It does.
You said there that this will override HR law.
Employment law, yeah, because it's a statutory law. It's things like, you know, this is down to protection of the consumer, and so that will override it. But you've still got to be careful and perhaps take some legal advice as to exactly how that will work going forward, because you cannot say anymore, I've got a standard, if somebody leaves under a settlement agreement, you have a standard reference where both sides agree, and it's that's all that can be said. But of course, something comes out later on, and then you need to notify, otherwise you're breaching a statutory responsibility. Then that could be, you know, it could be a tricky situation. But some of the inquiries that we've raised this question is that it will, you know, it will be at the head of employment law, but it's still something I think to take care on it after this regime comes in, what you're doing with regards to that.
That then leads to the second question, that, and again you refer to the fact that there may be some sort of reference coming in from the regulator, looking at what they've got on their books. Can we take it as read, or do we have to say, well, okay, we've got that, we might need just to verify what they're saying? In other words, is there any accountability at their end?
Who's
the regulator. If, for example, David decides to come into my business and I need to make sure he knows what he's doing, and I go to the regulator and they say, yeah, he's done around, you know, okay. Can I take that as read, or do I need to, let me just check that?
You'll be doing references for previous employers, and there'll be a standard format. We'll be interested to see what they come back with on those, because that's it, yeah.
The FCA aren't normally forthcoming with any information about an awful lot, but they'll tell you when they've got a concern. That tends to be the way they play it. So the typical thing is there anything else you'd like to tell us? Or we think you need to do some more work on this. I mean, they can't breach confidentiality any more than the next person. But we've come across that with approved persons applications with the FCA, and someone hasn't done a thorough due diligence job on the person, and the FCA say, I had one when they went back to a 2010 case with HMRC. So nothing to do with the FCA, but they obviously talked to HMRC and do those checks in the background. And this guy had an unpaid tax bill. I can't remember the exact details. Nothing on his approved person application about any issues with any regulators or statutory authorities, and the FCA picked up on it, and he had to give an explanation as to what actually happened with HMRC. So, very interesting. They've got fingers everywhere, the FCA, but they won't give you information. They'll tell you to go and do more work.
Yeah, but they're expecting you to do a thorough investigation, aren't they? Much more than previously.
You mentioned on the senior management functions, the 1, 9 and 3. I also had written down some other notes about required functions, SMF 16 and 17, so compliance and money laundering. Is that just a general requirement, or?
No, I mean those.
Do you not see that as applying?
No, not in the GI sector.
Okay.
No, I mean it's quite cut down for the general insurance intermediation sector. There's very few bits of it that actually apply. When you get into investment contracts, then there's all sorts of stuff that is in there, and a lot of the certification functions, we've skirted over it quite a lot, but most of it's related to investment insurance, where you have lots of certification requirements. For general insurance intermediaries, including MGAs, it's really the significant management function, which, if you look at the systems and controls part of the FCA handbook, they've got a certification regime section there. I'm just looking at it here, and it's talking about significant business units, which is the oldest, that's CF29. But really, they're talking about, what's the impact of this business unit in the firm and in the UK in general, and how many customers. So they're really looking at quite large stuff here, and for the majority of firms, that's really not going to apply, which is why you don't see many CF29s in general insurance intermediaries. And the ones I have seen haven't really been needed.
Okay, I had another question on this as well. It's more around your personal thoughts, or around as in what you think. So, from my understanding of all of this, they were trying to review the rules so that we don't have another problem like we had with the banking. When you say an individual may hold more than one function, I just don't understand why they would say that, because surely you're increasing the risk of something happening with a conflict of interest potentially, or something. Would you not want to make it fairer?
Some firms don't have many senior managers, many directors.
A smaller firm, I don't understand that, but if it's a sort of, slightly larger firm, would you not think that?
No, on a larger firm, you would expect the those functions to be spread amongst the senior managers, amongst the directors. If there were 6 directors, you would expect really them to have 1 each. Yeah. Really.
And maybe a bit more variety in the board as well, for people maybe from sort of back office IT operations, sort of spread of the board.
Well, you should have that anyway, really, if you're of a certain size.
Okay, so for larger firms, you would really expect them to be individual?
I would, yes.
Okay, that's fine.
If you want my personal opinion.
Yeah. Okay, thank you.
No more questions?
I can't believe there are no more questions.
Again, this is coming from the standpoint of the insurer rather than MGA, well, associated with MGAs, and I think at some point they will get over that. We're preparing for a regime on the basis that management functions such as head of underwriting, head of claims, head of finance will certainly be certifiable people, but not senior managers. And then we're wondering about somebody in my position, like general counsel and head of compliance. Where does that fit? Because I know there was some debate about this, and I've rather lost track of where it was going.
Yeah, I think certainly in an insurer, head of underwriting would be certifiable. That's the right way of saying it. Notwithstanding this. Head of compliance, my reaction is no, but that's without really thinking it through. From we deal in the intermediation sector, so head of compliance in most of our clients we wouldn't deem to be certifiable function. Certainly in terms of having a significant effect on the business and the customers, you could argue that. I think it's a little bit remote personally, but certainly if you have got significant business units, you're dealing with a lot of customers and you've got a reasonable market share in that area, then I think that's where the certification will come in. But this is all under consultation still, so if you've got views on that, then get them into the FCA, because believe it or not, they do actually take views into account.
It's interesting. I went down with David Coon to the FCA when they were starting to push this out, just before the consultation came out. The chap that was doing it was very, very informative on what was going on. And then he stood there and said, am I the senior manager? I report to a manager. who reports to the assistant director, who reports to a director who sits on the board. He's the senior manager, but I need to be certified. And I thought, yeah, you can see where this line goes up. So it goes right up to the board level, and that's most of the time where it sits, isn't it? It sits at that stage. So if you're on that board, then you've got to make sure that you're okay. That way it comes back to the job description, it comes back to all the other factors as well. But it's quite clear where he said it. And he was an absolute authority on this. But of course he was just a policy advisor.
I guess the point is, why wouldn't you certify those who have significant responsibilities? So I've actually got the text in front of me beside it, because it was going to be my question as well. The FCA define it as a significant responsibility for a significant business unit. So there is subjectivity around the word significant. That from a general management control, why wouldn't you want to certify your staff, even if you do take the process and do it internal, so you've got that comfort actually that you have got right individuals working within your organisation?
Well, from an internal risk management point of view and a governance point of view, I don't see any problem with that.
And the cost is minimal.
Yeah. I mean, the significant business function is defined in systems and controls. And it actually says here, when considering whether a business unit is significant for the purposes of this rule, the firm should take into account all relevant factors in the light of the firm's current circumstances and its plans for the future, including the risk profile of the unit, its use or commitment of the firm's capital, its contribution to the profit and loss account, the number of employees, certification employees or SMF managers in the unit, the number of customers of the unit, and any other factor which makes the unit significant to the conduct of the firm's affairs as relating to the regulated activity. There's also talk in the same part of the handbook about the size and significance of the firm's business in the United Kingdom. So, yeah, you have to make a judgment call on a lot of this, but I think the FCA are really looking at the larger firms here. It may be a significant business unit to a firm, but in the overall sphere, it's actually not that significant in the industry as a whole. But again, I wouldn't tell anyone not to certify if they want to, because I think actually it's a good feature.
Why wouldn't you want to make sure that somebody's trained and you know, and the right person for that? Well, I agree with you. Just whether it's a necessity or not.
I guess the disparity comes in a limited firm type, doesn't it? Because actually we've got a wider scope of people in there that perform the certification regime that actually potentially would have a lower impact on the market as a whole by the very nature of the role that they're doing. So then when you're looking at the head of claims or head of underwriting, it's not comparable to the sole trader that may sit in Chichester and has a one-man band who will fall within the certification regime. So when you look at how that would apply for those limited companies, those that limited scope group into the corporate, you've got immediate disparity.
Well, sole traders, of course, are just like at the moment, they don't have approved persons, they are the regulated entity. And the same carries over to the
But they're approved to do their job.
Sorry?
They are approved to do their role, aren't they?
Yes, they are the firm, effectively.
Exactly.
On North, so,
On the training topic, don't forget that we've also got the IDD second page paper out and also third papers out as well. And that's talking about level of training, 15 hours a year. So you've got to remember that although this is in isolation, we've got to have consideration of other papers that are out there as well. Well, if nobody's got any more questions, the only thing I want to say, two things. First of all, to Dave, thanks very much indeed, really good. They actually have prepared a briefing note, which I put in my newsletter, which I've just got one copy here, and it's quite informative. It's only 4 pages. It breaks it down a little bit, which basically goes on to what Susan's been talking about. And you can get a hold of that. I'll say the newsletter will probably be coming out. Coffee's outside. There you go. Perfect. Well done, Rich. Meanwhile, guys, thank you very much indeed. Appreciate that.